Welcome everybody to the 2024 Tree Law Conference. Thank you so much all for coming. I've got lots of familiar faces here, lots of friends, lots of supporters, and people that I haven't met to date yet either, so it's really great to see you all. Thank you so much for coming. A little bit of housekeeping. There is no planned fire alarm, so if the fire alarm goes off, get out of the building via the fire routes. I think the gathering is out of the front. So yes, that's a little bit of an intro. So we're starting off this morning with some short, sharp presentations from a selection of speakers. And then this afternoon we're going into a mock mediation. Actually, quick one. Show of hands, who's been to a mediation meeting before? Oh, wow, cool. Okay, excellent. I've got some of you that helped me with the role play, so thanks for that. But I think that would be a great opportunity to see, actually, let's bust some myths and what does it look like behind the scenes of a real mediation. Ooh. I want to show you mine. Oh gosh, that's not going very well. So my session is on trees versus buildings, which it's a pretty wide topic. Tree versus buildings is the whole reason for me setting up tree law and for tree law to exist. So we live in a world where the Great Britain would be a deciduous rainforest if it was totally in its natural environment. But obviously we're human beings, we need to live in properties, and properties are often close to trees, and they can live in harmony, and they can live not so in harmony. Cases that arise as a result of trees and buildings coming into conflict are really what we specialise with at Tree Law. So I thought I'd talk a little bit about the business. So who is Tree Law? We're a firm that focuses on tree claims. Whenever I tell people that, their response is always like, ooh, that's a bit niche. And then they sort of go quiet and then say, oh, but my mum did have an issue with her neighbour. Oh, and I don't like this and that, and my local authority did that. And then out come all the sort of issues that they've got with various trees in their own lives. Tree law really does span across so many actual areas of law, from civil cases all the way to criminal cases, with some planning cases and some sort of statutory cases in the middle. And whilst doing all of that, the whole ethos of the business is to try and keep, where possible, the tree at the heart of the advice that we give. So who are Tree Law's clients? I may well have a couple of clients here in the building, so thank you for them. We act for a mixture of local authorities, for individuals. I've got people that are commercial landowners, for example, insurance companies, arboriculturalists, and basically that's almost like the whole gambit of people involved in this area of law. It's a really interesting profile of clients. And what is tree law? I mentioned earlier that it really does span across an awful lot of law. We're dealing with civil law when we've got claims of nuisance and negligence, for example. For example, subsidence cases involve the encroachment of roots from one person's property to another, so that's a nuisance, an encroachment over a boundary. You may well have injunctions trying to stop somebody removing a tree or trying to make somebody remove a tree. You could have a declaratory relief claim trying to determine actually who owns the tree. The number of trees I deal with that are on a boundary. And it's like, is it my tree? Is it your tree? Whose tree is it? Do we share it? That's quite an interesting question. Planning issues, trying to get planning permission for a build, which may well be building in the root protection area of a tree. That can be interesting. Statutory compensation claims often crop up when you're dealing with tree preservation orders and a planning authority refusing to permit the removal of a protected tree. Don't worry, come on, guys. And crime, if you've got somebody who perhaps has been involved in the felling of a protected tree. Also real estate issues, if you've got problems of a property and you're trying to sell it. So it really is a huge, wide gambit crossing all different areas of law. So as a business, tree law is UK-wide, so this is the coverage of the clients that we have for at the moment. So I'm based in South Wales. You might be able to tell from my accent. I never quite know whether I actually sound Welsh or not. I think I probably do a little bit. But the vast majority of my clients are in sort of London and the South East, so that was the reason why I really wanted to focus this year's conference here. But what I thought I'd talk about is the top 5 most common legal issues that I get asked to deal with by clients. Because after 3 years in business, I've gone into my 4th year in business, I can really start to profile what are the hot topics. And I think there is an absolutely boiling hot topic as the number 1. And I will leave you in suspense, as they do on social media, and so you've got to watch to the end to hear the top 1. So I thought I'd take them in reverse order. So the top 5 issues. Number 5 is criminal claims. Now I'm getting this quite a lot. I've got clients who are either being pursued in relation to a criminal claim for illegally felling a tree, or local authorities who want to pursue a private prosecution for the felling of a tree. Now this is really interesting. It's really where civil and criminal claims really do come together. You may have, if somebody wants to take action, or if somebody is frustrated by a tree in a neighbour's garden and they decide to take action and they go above and beyond what they're allowed to do, that could potentially be trespass onto the tree owner's garden, and if they carry out too much work to the tree, that can be criminal damage. So that's where it starts to bring in crime. Now I tell clients that if you've got that sort of crime, if you're sort of phoning 999, I'm doubtful the police are going to come, even though it is a criminal act. I think that's obviously on a sliding scale. And if you phone the police and say, I think somebody's taken one too many branches, probably not. But then if you phone the police and say a developer has felled an ancient woodland, they probably will be a little bit more interested in that. It's even more interesting in that criminal claims, if you've got a planning authority, for example, wanting to exercise their regulatory function in looking after protected trees, if there's a crime which is being committed, then the planning authority can actually pursue a private criminal prosecution. So the planning authority sort of step into the shoes of the police. So it's them that do the interviews under caution, gather the evidence, and pursue the criminal claim. So that's exciting, getting involved in criminal cases. I was commenting to Jack earlier that being in the criminal court is very different from being in the civil court. It is incredibly feisty. Number 4 is mitigation requests. So for those of you who are involved in subsidence, you'll know all about mitigation. Mitigation relates to claims in nuisance and negligence. So this is, for example, if a client phones me and they are a tree owner and they have received a pack of evidence from somebody, probably a neighbour's insurance company, that says, here is a pack of evidence that shows your tree is causing damage to our property and we want you to do X, Y or Z to the tree. Now that could be we want you to reduce it in size, we want you to chop it down, or it could be we don't want you to do anything, but please make sure that over the next 5-10 years it doesn't get any bigger than it currently is. So what I often find with people with these queries is they've received what they perceive to be a robust letter. It's often got a lot of legal jargon and terminology in it, and it can feel quite intimidating to receive. You know, they get a letter that says, here's the evidence, and unless you do it, unless you chop your tree down, we're going to have to underpin your neighbour's house, and then we'll sue you for those underpinning costs. And FYI, we think that's probably going to be about 200 grand. So obviously that lands, they go, oh my God, what on earth is going on? Don't know what to do. So those are pretty hot topics that I get from clients. The first thing that I'll do is say, do you have any insurance cover of your own? And perhaps have a conversation with your insurer. But one thing I'm learning is a lot of people don't have insurance cover. A lot of people don't. So yeah, that's why they end up coming to a lawyer to speak about what to do with their mitigation request. So that's number 4. Number 3, tree safety. I hear this a lot. So I have clients phoning up saying, I'm really worried a tree that's owned by somebody else is looking really, really ropey, and I'm worried it's going to fall down. And if it falls down, my house is in striking distance of the tree. It may well be a tree in a neighbour's garden. It may well be a tree on a highway. Yeah. And they're thinking, what can I do to make myself safe? Now, quite often, and I'm starting to learn to ask this, it's often not really about the tree. It's often about the fact that these two neighbours hate each other. and the tree is the fall guy. The tree is a good reason to sort of start going legal on your neighbour. But there are some really justifiable cases in which tree safety can be an issue. I've got a couple of tree safety cases on, so I think it's a case of trying to encourage that client to get some independent evidence to say, to confirm that yes, that tree is at risk of failure in the imminent future, and then to take steps to see what we can do to get some works to make that tree safe. In all these situations, a local authority, my understanding is a local authority, no matter who owns the tree, if it's in an absolute perilous state of imminent failure, they can step in and use some powers to make that safe. I've not been able to get a local authority to do that so far, perhaps because nothing's actually been too unsafe, although one did fall down, yeah. But it can be quite a difficult process to try and determine that it actually is at significant risk of failure and to go ahead and get those works done. Often a letter, the client will be comforted by a letter going to their neighbour or to the tree owner, whoever it is, to say, look, can you just carry out a check? A bit worried about that because if you do it, if it falls, it's going to hit my house or my newly built garden office or something like that. That's an interesting one. It's going to hit my newly built garden office, which I built in the root protection area of the tree that I'm worried is now failing. And overhanging branches. If I had £1 for every time a client rang me about overhanging branches, actually there's so much law involved in overhanging branches, it's really complex. But these are the sort of 3 arguments that I get in relation to overhanging branches, and I get them argued in both directions. So the first one is light. A client can say, I love trees, but this is blocking out all of the light in my garden, and it's the reason I bought my house, and I'm really depressed, and can you please get something to happen to the tree? No poop zone. I know, I didn't think I'd ever talk about poop so much as a solicitor, but the number of, oh my goodness, I hate the pigeons that are roosting in the tree, they're pooing on my car's new, it's got expensive paintwork. And leaves, the number of people that hate leaves and they're absolutely outraged by the fact that autumn comes and leaves land in their garden. Should they put up with it? They try and, but they just can't. So they're the sort of overhanging branches queries I get. Overhanging branches gets really interesting when you add that into a tree which has got a tree preservation order on it. Because tree preservation orders, I was talking earlier about criminal sanctions, you've got local authorities who can step into the shoes of the police and pursue a public prosecution. But TPOs, a TPO tree with overhanging branches, it's actually the neighbour who experiences the branches in their garden overhanging that seems to have the most rights out of anybody in regard to a TPO tree, because the owner of the tree can't touch it without permission of the planning authority, but the neighbour into whose garden those protected branches might encroach do have the ability to take action even though that tree is protected. So it's an unusual one which gives that neighbour almost the most rights. So that's suggesting what's going to come in at number 1. Anyone got an idea what's coming in at number 1? What might be my hottest asked question? Go on, Naomi, you look like you're going to shout something out. Yes. And the winner is TPOs. Tree preservation orders are an area that feels absolutely ripe for it's going to say a revamp, but definitely some clarity. So I get people phoning me. I've got clients who are owners of tree preservation order protected trees that actually may have owned those trees for a significant amount of time, and they think the trees still belong to the local authority and they don't actually own them. So they're not sure, they're just not sure of what their rights and responsibilities are. So I get questions about that, what their rights and responsibilities are. I get questions about how to make an application to the planning authority to carry out works to a protected tree. Those applications don't have to be made by the tree owner, they can be made by anybody. I could make an application to work on a protected tree that's in Anthony's garden. You might not like it, Anthony, but I can still go ahead and do it. And as I was saying, tree preservation order trees are nuisance. It's that weird bit of law which means that even if the tree is protected, if it's encroaching and if it is creating a legal nuisance, not just like, oh my goodness, that's a blooming nuisance, but a legal nuisance, then that gives the owner of the land onto whose land the roots or branches have encroached, it gives them an ability to take steps that the actual tree owner themselves wouldn't be able to take without the permission of the planning authority. Also get questions on how to make one. I've got a client at the moment with an oak tree in their garden, which their neighbour is actually taking advantage of the ability to cut back branches to the boundary line absolutely forensically. So you've got one of those sort of comedy photos of an oak tree with a huge canopy on one side and then literally sliced like that down that side. She's wanting to get additional protection for that tree by putting a tree preservation order on it, which sounds like that could help, but actually I'm trying to explain that yes, it would protect the tree almost against you, but his rights to continue to cut back to the boundary line would still exist. So it's definitely an area ripe for change. I know there's a couple of people here that would agree that the TPO rules do need a revamp. I thought I'd mention 2 case studies as well. I won't name any names just in case anybody involves here. Both of them were incredibly similar but had a very different outcome. Both of them involved oak trees. Both of the oak trees had a tree preservation order on them. Both oak trees were implicated in subsidence damage. They had a very different outcome because one local authority, one planning authority, was quite entrenched in their views, and they didn't want to hear the evidence as to alternative solutions to tree removal. As a committee, they'd made the decision that the tree was implicated in the damage. Leaving it where it was going to be too risky, not only risky in relation to the damage to the currently damaged property, but a risk of causing damage to other properties in the locality in the future. And I feel like they plucked a figure out of the air, said, we're worried it's going to cost us £400,000, so therefore we'll agree to take the tree out. No conversations were had with the other parties that were involved, very little by way of an update, and the tree was felled. It was one of those cases that hit the press. It was a couple of years ago now, it got some press attention. The clients in that case were a campaign group. They were absolutely devastated. It felt like a very sad outcome. After that, I had a conversation with an engineer who'd been instructed by the planning authority to give an updated view. And he came to me afterwards and said, oh, what happened with that tree? Because, I advised the planning authority that, it was fine and it could just be left there. It wasn't implicated at all, nothing to worry about. And it seemed that they'd got so far down that path, that political element of it, which I don't think I'd given that much attention to before, that sort of they'd committed to it as a committee, they'd decided that was their action. It was almost like it got a energy of its own and it couldn't be stopped. No one wanted to say, hang on a second, do we actually want to do this? That was a very sad outcome. But the reverse of that is a happy outcome. Very similar scenario. We had a TPO protected oak tree implicated in damage to 3 properties. This wasn't one with possible others, this was 3 on the go. But the planning authority really, really wanted to keep this oak. It was one of 2 oaks that were either side of an entrance to a new modern housing estate. It really was a feature. It was a landmark. So the planning authority wanted to keep the oak, but also appreciated that this evidence was showing that this oak was the cause of the damage. And they were thinking, how can we work together with 3 different insurers, 3 different batches of site investigation to all see, can we work together to solve or stabilise the properties and keep the oak? So we ended up having almost like a mediation. We had an off-the-record, cards on the table, doesn't matter what the law is, who's responsible for this, that and the other, let's work out, is there a way that we can sort this out? And the outcome of that was that the decision was made that a root barrier was a feasible option. There was a lot of work done in working out how that could be installed, and it was agreed that that would be installed, and actually everybody contributed towards the cost of that. Even the planning authority, who actually, if you went through the law, they probably didn't have a legal responsibility to contribute towards that cost. But they realised that in doing that, in taking a flexible approach and doing something that wasn't necessarily set in stone and set out as the law, meant that everybody could walk away with an outcome that they could stomach, they could be happy with. So that was a great outcome. So I think 2 very different outcomes to 2 very similar situations. So that's it from me. Just a bit of a whistle-stop tour, introducing myself, talking about my hot topics. If you want to work with us, then get in touch. You know how to find us, or come and grab me and have a chat. And I hope you enjoyed today, and I will see you later when I'm role-playing in the mediation. So thank you very much. Do you want me to turn it into a slideshow?
Yeah, please. Hello. Good morning, everyone. My name is Tony Byers. I'm from Zurich Resilience Solutions. I'm a liability risk consultant, and today I'm going to be talking to you about 2 things mainly. So the agenda for today's presentation, I'm going to share with you some tree claim data from 2019 to 2024, and I'm going to talk to you a little bit about how Zurich Resilience Solutions can potentially assist yourselves, or at least shed some light on what we do. So, first part is the tree claim trend analysis. So I was able to get my hands on a lot of claims, and it took a fair amount of time to actually start going through some of this information. So I looked at 6,141 tree-related claims over the period of 2019 to 2024. Obviously 2024 hasn't closed out fully yet, so we're still expected to see an uptick in some of the tree claims that will be coming through. A few wee notes on the data. It does cover data from personal, commercial and municipal customers, and there are some inherent errors within the data, okay? The reason for the errors is to do with virtually everyone involved in the tree claims themselves. So it could be the individual claimant thinking it's a tree claim, it's actually nothing to do with the tree claim, or just basic, typical errors. Things such as someone calling a tree claim when it's actually a car that's hit a tree rather than a tree that's hit a car. Okay, so it's sort of bugs in the system a little bit. The other one which I've raised is ground movement. I'll come on and talk about this a little bit later on. However, we do have a significant misnomer in terms of ground movement, where tree claims are raised and they say the proximate cause is ground movement. And we actually look at it, once we investigate, we find it's nothing to do with ground movement whatsoever. Not all the claims are finalised, so we do expect the costs in these claims to increase over time as well, so that needs to be considered. So the split by the line of business, the vast majority of the claims that we see are casualty claims. So that's claims where there's damage to property or injury to individuals. Motor claims as well, that tends to be where a branch has fallen off, struck a car, or a car has alleged that tree roots have ingressed and caused problems on the highway, and therefore has caused an incident. And then the last one is property itself. Some of the casualty claims that we see, they are property claims, and some of the property claims we see are actually casualty claims. Again, it's slight errors in the way that we record data, and we are looking to finesse that so we can provide much more accurate information, also so we can inform what decisions we're making going forward. In terms of the finalised status, the settled claims, so 54% of these claims have been settled completely. So we've made a payment on them. We found that they're a legitimate claim and some form of settlement or redress is due to the customer. The other 46% of the claims have been closed with nil payments. That's a case of this was not a valid claim in itself and therefore it's going to be closed off completely, or they've been repudiated. We've looked at it and said it could be a valid claim, but we rejected the claim because the individual who the claim's gone in against, or the organisation the claim's gone in against, we found they have not been negligent in their actions. So looking at the data going forward, we have seen that from 2019 to 2024, there's been a steady decrease in the amount of claims we've actually seen relating to trees. There could be multiple reasons for this, and some of this is down to my own theorising as to how it's happened. Partly it's to do with organisations becoming better at understanding what their own duty of care is, what their own responsibilities are, and when a tree claim arises, they're able to better defend it. Once that word gets out, individuals are less likely to actually submit a claim. When it comes to the count by month, we can see that there's a significant proportion of the claims happen during the winter months, and I'll come on to that in a little bit more detail. Next thing I would like to look at is where it starts getting interesting when we start looking at the data. Total number of claims. So the one that pips the post for all else is storm claims. Claims related to a named storm event where there's been damage to a tree and it's therefore caused injury or damage to someone else's property. Next on the list, and if you put them both together, you'll find that they actually are significantly more, which is ground movement and subsidence. Both can be categorised virtually the same. If you were to add the two of them together, they would be the largest amount of claims there. But again, there's some bugs in the system with that. What we do know is the average cost of claims, the subsidence claims, the ones where we have a payout, they are significantly more than virtually any of the others. So subsidence and ground movement, you're looking at average claim costs of around £10,000, whereas the storm claim costs are only coming in about 9,000 themselves, sorry, 7,000. Therefore, when we do have a subsidence claim, it's a lot more expensive to us. However, the total reserve, the amount of money we have to set aside to deal with these claims, ground movement and subsidence hit the post beyond all else. So we would think then our greatest area of concern would be subsidence or ground movement claims. However, this is incorrect. When we start looking at the misclassification of errors, we actually see that there is a misnomer here. Although ground movement and subsidence do hold a significant part of the reserve, the storm claims actually cost us more on average. The ground movement and subsidence claims, only 31% of these claims actually finalise with a paid claim. In comparison, for storm claims, 75% of these claims result in a claim being paid, where the claimant has proven that the organisation or the local area authority has been negligent in their duty and they failed to actually cover off their duty of care and do everything they possibly can to prevent an incident occurring. We'll look at some of the reasons why those claims fail at a later stage. This next slide breaks down the count of month by predominant cause. So what is the predominant cause over a period of time? So the ones that are mixed, they cover 4 months of the year. Storm, however, covers 5 months of the year. So there's 5 months of the year where the majority of the tree-related claims we see relate to storm damage itself. And subsidence, as we see, falls mainly within the summer months itself. Going on a little bit further, it shows you the breakdown. So as you would expect to see during the winter months, during the months where we are going to have more aggressive weather, storm claims are predominantly found. The mix is a mix between storm and subsidence claims, and then obviously during the summer months, when it's hotter and there's more moisture being taken out of the ground, we see an uptick on subsidence claims itself. However, when we start looking at the reserve by month, and we put that in comparison to what we've already seen with the predominant causes, we actually see that the months where we're going to find storms, our reserve increases significantly. So we're paying more during the months where we are receiving storms. So it does kind of flip the paradigm a little bit. Where we usually would think subsidence would be our greatest threat, we actually find it's storm damage with trees. And that's coming purely from the claims data over the last 4 years. Again, this is backed up by the conclusions of the data. So we can see that subsidence does remain one of our highest individual claims averages. However, storm damage is the predominant overall cost to our customers. The majority of the storm damage are closed or settled with a settlement given to the claimant as well. The vast majority of the subsidence or ground movement claims are closed with no settlement offered because there's no negligence proven or they're a misclassification. Therefore, storm claims are more likely to occur, and inherently they're harder to defend against for our own customers. I did look into the predictions in terms of storm damage, what we were likely to see actually occurring over the next few years. Now, I would caveat it. The thing that's going to cause the most amount of damage to a tree is ground wind speed. Okay, it's the actual wind whipping up the trees and pulling on the tree, causing the organic structure to fail. Now, that's not in itself predicted to increase significantly. Okay, and that does come from the Met Office themselves. They are predicting that over the next 30 years, it's not really going to pick up significantly. However, what they have concluded is the amount of named weather events, so named storms, they are going to increase. Maybe not exponentially, but steadily. And that's a prediction which takes us up to 2081. So we are going to see more storms. We're going to see more aggressive weather. And again, we are also going to see exacerbations when it comes to subsidence as well. Hotter summers, drier periods and wetter winters as well. All these lead into an exacerbation. So we are going to see an uptick in claims in general related to trees, whether it's in subsidence, which is more expensive, or whether it's in storms, which actually costs us more per year. So, ZRS services. How can we assist? The common causes for settlement. This was one that I was quite interested in. Why do claims fail? Why are we having to pay out? Or why have we been found negligent? The first and foremost one is the failure to document. Most organisations, most local area authorities have good policies, have good structures in place. They allow them to inspect, to adequately zone. However, they fail to document it accurately. So when it comes to a claim arising, the failure to actually provide evidence in black and white means that we have to admit liability, or we have to at least settle the claim without an admission of liability because there's something fundamentally missing. So the associated failure for that is an operational or policy failure in itself. Our service suggestion of that, first and foremost, we would advise to do an asset management grading. I'll talk about that in a little bit more detail later on. The other thing we would advise is a policy review, ensuring your foundation structure, your policy itself, is fit for purpose, and it is actually supporting your system of documentation. The next one is the failure to inspect adequately. So where you are inspecting, you're failing to inspect in an appropriate manner, which allows you to actually prove that you're doing everything within your own duty of care to ensure that the trees themselves are inherently safe. Next is a failure to maintain. So where you are inspecting, where you do have a good zoning process, but you're failing to actually get on top of your maintenance procedures, or you're falling behind on those, you'll be held negligent for that as well. You are determined by your own policy, what you set out, what you say is reasonable. If you fail to adhere to your own policy, you will be found negligent. Again, the next one is the failure to appropriately zone. So sometimes you're giving yourself a zoning procedure where you are giving yourself a duty to inspect or maintain at a much higher level than it really is adequately necessary for the type of area. There are certain areas within local area authorities especially where there is no duty to actually actively inspect. It's only to deal with it by exception or deal with it by complaint because it's a large forested area. You might inspect around the perimeter, but in the internal part of a forest, There is no necessary duty for yourself to go in and inspect every single tree there in the same way that you do with trees lining a road, for instance. And the last one is negligence, so employee or contractor. Effectively, where you've set out a procedure but someone's been negligent in how they've conducted it, how they've conducted some of the tree surgery work that they've been asked to do, and it's therefore led to an injury or damage at a later stage. And in those instances, we always do have to offer settlement because it is fundamental negligence. With all these, you can see that there's a varying level of service suggestions that we advise, whether it's asset management gradings, policy reviews, or targeted training. So I'll go through some of those now in turn. So the first one we do, the asset management gradings. This is kind of our bread and butter at ZRS. We go out to organisations, be it a local area authority or a business or an individual owner of land, and we can grade them against other customers. So we go through a holistic view of their tree risk management practice. We look at things such as their strategy, planning support, their inspection regimes, maintenance and repairs, monitoring and reviewing, contract management, visitor safety and access controls, operational activities on site, as well as their records. Actually, it's a cyclical thing. It's not something where we start and we'll look at it just individually. It all ties into each other. And only when there's fundamental strength with every aspect of that do you have a properly strong process in place. We also act as a critical friend with this. As much as it's a grading, it's not an audit. We're not there to catch you out. We're not there to trip you up or basically make you feel bad about what your operational procedure is. It's there as someone who can highlight things where things could be slightly better. What we do find though is organisations which engage fully with this process, they actually find that they optimise their own processes and their own operation. It's not just about providing claims defensibility, which is an important part, especially as we see it as insurers, but it's also about effectively saving yourself money. You might be doing too much in an area where it's not necessarily required. The next service we offer is policy and strategy review. Some individuals in this room have already engaged with me in this process and find that it's very useful. I generally use this as a starting point before moving on to an asset management grading. We start with a policy review. So what is it? It's a holistic review of your tree management strategy and or its policy. If they're two separate documents, you can do it as two separate pieces of work. If it's something that's joined in, or if it's something which is attached to, say, a highways policy, we can look at it holistically as well and understand how it's really complementing itself. The review of the documents is done with a claims defensibility mindset. Okay, so we're looking to ensure that if a claim arises, how's this document going to aid you in defending a claim? The mindset as well, also it ties into the asset management gradings where a really solid policy itself will help to optimise your operation. So when's the best time to engage with ZRS for a policy review? Generally it's when you're approaching the end of your policy or you're approaching the end of your review period, or if you're wanting to make ad hoc changes to your policy, if you want to do something to shake things up, or you've had a manpower change or person power change, or any other significant change to your policy, that's probably the best and most optimal time to actually engage with us. And who can we consult? Any organisation. You don't need to be insured with Zurich for us to engage with you. And that's the main thing to take away from that. Next one is training services. So what do we offer in terms of training? Basically anything you can think of, we can offer training in. We do have specialists, risk consultants and training providers who are able to engage to offer you bespoke training. So it will be training which is focused on what your needs and requirements are. We don't have an off-the-shelf training package. We generally design it from the ground up in consultation with you as individuals to ensure that you're getting the maximum bang for your buck. It can be in person or virtual. Only thing I would say is though, personally I prefer to do in-person training. You tend to get more of a benefit, more of a feedback from the individuals, especially when you're speaking about training provided to arboriculturists, tree surgeons or inspectors. They tend to be the type of person that if you're doing it behind a screen, they slightly switch off. Again, you don't need to be a Zurich customer for this, and some examples of the training we do provide, ground-based tree inspections and claims defensibility training itself. Just finally, I would want to share with you, I'm not going to read through that because it's very self-congratulatory. However, some of the feedback, we have engaged with some of these customers before with policy reviews, with training services, and they've all provided very positive feedback on some of the services we provide. And that's everything for myself. I would usually open to questions just now, but I think we'll probably do that a little bit later. If anyone would like to speak to me about any of the services we provide, please do find me later on. I'll be the guy standing beside the big ZRS banner. All right, thank you very much for your time.
Good morning, everyone. Thank you very much, Sarah, for inviting me to speak here. My topic is going to be on Japanese knotweed, which many of you will know has been there's been a huge increase in Japanese knotweed litigation over the last 4 years. There are some courts in South Wales that have to donate entire, a day a week, every week, just to get through this enormous, I was going to use the word encroachment, which is a horrible pun, enormous rise in Japanese knotweed litigation. I'm also going to speak in particular about a case I was involved in earlier this year, which was the Supreme Court decision in Davies and Bridgend, which is a very important case on causation, but not just for Japanese knotweed, actually causation in all cases of natural nuisance, property damage. So I will skip over the scientific details because I can see this audience is better qualified than I am, but you will know Japanese knotweed is an invasive species. It was introduced in the early Victorian period into the United Kingdom. By the end of the Victorian period, they realised they had a problem. The points you need to know are that Japanese knotweed spreads via an underground stem system called rhizomes, and they are similar, but in many ways largely dissimilar to tree roots. Crucially, from a legal perspective, Japanese knotweed is classed as controlled waste for the purposes of the Environmental Protection Act 1990. Now, that's extremely important when it comes to civil liability. What it means in practical terms is, if you are digging up your garden and you come across Japanese knotweed, you cannot simply bag it up and throw it out with your household waste. You are legally obliged to engage a contractor that is licensed by the Environment Agency and dispose of it via them at cost. So you can see that the presence of Japanese knotweed imposes this financial imposition on homeowners, and that's going to be very important from a legal perspective. I think the next point to note is the Ricks paper of 2012, Royal Institute of Chartered Surveyors. They published this paper in 2012, primarily, I think, to give assistance to mortgage lenders and the like. The paper was counterproductive because, in effect, it was extremely alarmist, and it, for instance, raised it stated that Japanese knotweed could spread laterally about 7 metres and very quickly. And so Japanese knotweed on a defendant's land poses a risk to the neighbour, and that becomes very important from a civil liability perspective. And this effectively is what triggers this epidemic of Japanese knotweed claims that we've had over the last decade or so. So the key, or the seminal case in Japanese knotweed litigation, and if you're going to read one case before you read my case of Davies, it's Williams and Network Rail. What this case does is it establishes how, in legal terms, Japanese knotweed causes damage. So in Williams and his neighbour called Waystall lived adjacent to a railway embankment.